On behalf of the president, of the rector of the university, Professor Roberto Di Lenarda, I'm glad to open this session of seminars, and I'm glad to give a warm welcome to our Swedish guests who are planning to give seminars and to present their view on a problem which is peculiarly important for Italy. Especially since in Italy we have a lot of small, medium enterprises who do not have the power, the legal power sometimes, to access claim and procedure in court. The problem that you will be tackling today, it's particularly sensitive to us. So how to ask for money and what to do if the money which is due to you is not given in time. It's a sensitive problem again. So without any further ado, I'd like to wish you a fruitful seminar. I have to go back to the president's room, so I cannot stay with you. But by all means, enjoy it, and especially I hope that the students will enjoy this. Thanks, Sarah. Before actually I go away, there are some small presents. Did you plan to go see the museums later on?
Of course.
So you will actually even see the museum, which is represented. It's a good collection of Italian contemporary art. We'll see it later on. Very much. Over there. And here again.
Thank you very much.
I will scold you separately for not having fixed everything on time.
Thank you very much. So thank you very much to our deputy rector, to the rector. I have to bring you the greetings from the head of the Department of Political and Social Sciences. And I am very glad to have you here and in this difficult situation. We know the topics of our seminar, and so I leave the floor to our first speaker, who is Professor Erik Bijlander. Erik Bijlander is a full professor of procedural law at Uppsala University.
Hello, good evening, everyone, or good afternoon. And welcome to this international training seminar on the EOPP and the ESCP regulations. Coming from Sweden into a European setting, of course you are carrying Sweden with you. Even if we are going to hear presentations about common European instruments, I think it's important to realize we are not only Europeans, we are also Swedes or Italians or wherever in the Union we are coming from. And talking about the specifics of different European instruments, we are marked by our background. That is the reason I will speak some about not only common European topics in this introduction, but on Sweden and Italy from certain perspectives to set a background for what will come. And rather than drawing conclusions from a comparison between cultural specifics, I will provide you with some food for thoughts. Please draw your own conclusions if there are any to be drawn. So what is most specific to what I will say is an introduction to the Swedish legal system. So we suppose you are, as an Italian or mainly Italian audience, well aware of your own system. And it would be strange for me to try to introduce and say anything thoughtful about the Italian system as such. So An introduction to the Swedish legal system is also an introduction into the Swedish legal culture, and legal culture being part of the wider notion of culture. So from where am I and my colleagues? And how do I change this? It's down there.
Down there.
Yeah. So my name is Eric Bylander. I'm here together with some good colleagues from the same university, but also from the practical life of Swedish law. And my colleagues will introduce themselves later on. Behind this mask, which I wear for obvious reasons, my trademark is to be found, this peculiar mustache. I pointed out where Uppsala University in Sweden is situated. It's like 70 kilometers north of the capital, Stockholm. And Uppsala University is the oldest university among the Nordic countries. Inspired mainly by Paris, but also to some extent from Bologna. But that's back then. Nowadays, Uppsala is also a very modern university, cooperating with a lot of different other universities. Now, the University of Trieste, and we are very happy about this cooperation. Some statistics, and I'm not the one who's invented this, and I'll try to explain what I've understood from what is called the Hofstede model of natural culture. So this isn't specifically about the differences and similarities between Italy and Sweden when it comes to legal culture, but the culture mainly dealing with doing business and work life. This is a country comparison from the Hofstede Insights, and there are 6 different aspects included in this model of measuring national culture and comparing national culture. Italy is represented by the blue lines here, and Sweden with the purple ones. And what are the similarities between natural culture here? Well, the second one here is IDV, and it stands for individual or individualism versus collectivism. And we are both quite individualistic countries. Individualism in this sense can be defined as a preference for loosely knit social framework, calling for a strong state, you could say, in which individuals are expected to take care of only themselves and their immediate families, and then the rest is left to others. But mainly you are supposed to be an individual. And so Italy and Sweden are quite similar in this aspect. There is also a similarity between the long and short-term orientation, LTO, so-called. And every society has to maintain some links with its own past while dealing with the challenges of the present and the future. We can recognize it especially in times like these. Societies who score low on this dimension, for example, they prefer to maintain time-honored traditions and norms, while viewing societal change with suspicion. So both Italy and Sweden could be called quite modern societies. This will be even more obvious in a map to come. Where we find the biggest difference between the countries on this Hofstede model, which is, of course, like every generalization, wrong in several aspects. That has to be stated. This is on a very wide scale, and you could always find aspects which doesn't fit into the model. However, what is somewhat misleadingly called masculinity versus femininity, there is a huge difference, where Sweden is on 5 on this index MAS, where Italy is on 70. What is then meant by masculinity versus femininity in this? Now I hear myself. Ah. Sure. In the business context, masculinity versus femininity is sometimes also related to as tough versus tender cultures, which would make Italy a tough culture and Sweden a more tender culture. Nothing in these different aspects say that anything is better in any way than the other, only that it's different, and it states how it is different. And the masculinity side of this dimension, the masculinity versus femininity, represents a preference, and all this is about preferences. A lot of people have been asked about their preference in different dimensions. And this is for achievement, heroism, assertiveness, and material rewards for success. And society high on the MAS is more competitive, while a more feminine society stands for preference for cooperation, modesty, caring for the weak, and which would be somewhat surprising, quality of life. And then society at large is more consensus oriented. And at least this aspect is something that can be related to in Swedish terms when it comes also to legal culture. Sweden is a very consensus oriented society at large. I will leave the other aspects uncommented here and now.
Okay.
See? Yeah, sorry. There we are. Another comparison between Italy and Sweden could be made by help of CEPEJ, the European Commission for the Efficiency of Justice. And this commission has provided lots and lots of statistics on the member states of the European the Council of Europe. And I do recommend visiting the CEPEJ Stat dynamic database of the European judicial systems. I only highlight 2 different aspects here, which is quite surprising. The number of professional judges is one of several aspects you can find where Sweden actually has more professional judges, not many, but more professional judges than Italy. And not surprisingly, in view of this, the so-called disposition time in civil and commercial cases in first instance courts is in Italy 527 days, which would be like 1.5 years, and Sweden 166 days, like half a year. But to know what this, how surprising this is to see, you should do another comparison, and I do wonder where that slide is. Sorry about this. This is not the right one. I better tell you then. Sorry.
Do you need some help?
No,
Okay.
apparently I sent you the wrong version. Then you should realize that Sweden is a much bigger country than Italy. It came as a surprise to me, actually. Sweden is 49% bigger when it comes to the area. However, Italy is a much bigger country when it comes to population, where there are about 60 million people in Italy and about 10.4 million people in Sweden, making Italy 6 times, the Italian population 6 times the population of Sweden. And the density of population is then like 23 persons per square kilometer in Sweden and 200 in Italy. Considering the huge difference in population, you can see that the number of professional judges is quite appalling.
Sorry, I
Yes.
don't see your face.
Ah,
Let's try.
sure. Not
Now?
much
Is
to be
it okay?
seen now, but
No, your eyes.
yeah. So this is the outcome, so to say, and as I said, I do recommend you all to visit this quite interesting page where you can choose only a couple of countries and certain aspects, etc. It's quite enlightening. The Swedish court system is based on the fact that Sweden is one single country, not divided into Bundesländer like Germany or any other undergroups of different states. And then there are 2 parallel lines of courts, with one Supreme Court in each of them. The Supreme Court, which is only supreme within the civil and criminal tiers, on one hand, and the Supreme Administrative Court in administrative cases, which includes, for example, taxes and disputes between authorities and physical persons. And this is the Högsta domstolen and the Högsta förvaltningsdomstolen on the top. Under each of them, you find a court of appeal or an administrative court of appeal, that is hovrätt versus kammarrätt, and there are 6 of the court of appeals. The Swedish delegation here today is represented with one judge from the Court of Appeal of Stockholm, Svea Court of Appeal, Samuel Rudvall. You will hear more from him soon. Under each Court of Appeal, respective, and the Administrative Court of Appeal, respectively, you find 48 district courts on the general court side, and only 12 administrative courts, förvaltningsrätt. There are also some specialized courts, even if the trend has been to include specialized courts in the the court system itself. So, for example, migration cases are tried within the administrative courts, but in a special setting within the court system, making the special courts very few in number. The most important worth mentioning here is the Labour Court, situated in Stockholm, just like the two Supreme Courts I've mentioned. I want to say some about fair trial in general. This is nowadays a concept in internal Swedish law, where you can see in the instruction of government, one of the fundamental laws, that legal proceedings are to be carried out fairly and within a reasonable period of time. And this is intended to meet the essential elements of Article 6 of the European Convention, being similar to Article 47 of the Charter of Fundamental Rights of the European Union. And of course, as you all know, this is part of our common legal framework. Unlike the Human Rights Charter, there is no delimitation to civil rights and obligations or criminal charges or EU law. So every court case should be under the standard of fair trial according to the instrument of government. When it comes to enforcement, Sweden has a system that works relatively well, since we have one authority, the enforcement authority, Kronofogden, or literally the bailiff of the crown, the state authority of enforcement. And they handle not only public enforcement titles, but also private. And an application for a payment order, be it a Swedish one, internal Swedish one, or the European payment order that we will hear more about soon, it is submitted to Kronofogden. And Kronofogden, or the enforcement authority, is an authority under the government. So in a sense, of course, it's not a court, but its function is the function of a court when it comes to the European payment order. It should also be stated that norms on fundamental rights and freedoms that emanate from the European Union jurisprudence and the European Court of Human Rights has had an impact on the rulings of the Swedish courts that is, at least before, far greater than what the Swedish constitutional norms enjoy in their own right. So constitutional, we have no, as you could see from the overview of Swedish courts, we have no constitutional courts. You could say that every Swedish court is entitled and obliged to function as a constitutional court, but we have no certain constitutional court. And those are the pages I had included here. I had a couple more in the presentation I wanted to show you, but I think I stay here and maybe.
Yes. Ah. Here we are now.
Yeah.
Where are your pages?
Oh, no. This. I think we just stay there.
Okay.
And should we have a short break now and then
Yes,
continue?
we can have a break.
Yeah?
Okay.
So before we will get the opportunity to hear more on the European payment order, we are having a break of 15 minutes. Yeah? Okay. Thank you, everyone.
Now I can leave the floor. Fredrik Sjoval and Samuel Rudvall are going to speak about the regulation about the European Order for Payment Procedure. We have had already a presentation by Eric. Samuel is judge of the Court of Appeal in Stockholm, and Fredrik Sjoval is part of the Swedish law firm Mannheimer. And Fredrik has served as agent of the Swedish government at the European Union Court. Fredrik is an expert in European Union procedural law and author of a Swedish language commentary to the Brussels I regulation.
Great to be here. My name is Samuel Rudvall, and I'm an appeals court judge in Stockholm, the Appeals Court of Svea, as Sarah said, and my colleague here is Fredrik Sjoval, the lawyer from Mannheimer Swartling. And we are here today to talk some about the European Order for Payment Procedure. And the reason for this is because yes, let's show it. We wrote a Swedish book, if anyone's interested. Well, it has a nice color, and it's a commentary of some of the European private law regulations, primarily the Brussels regulation, but also about the European Order for Payment regulation. And that's sort of how we ended up here. This regulation has been in force since 2008, but I think in a European perspective, and also the Swedish one, is that it's scarcely used. Even though it's quite good, well drafted, and offering the prospect of a smooth process for debt recovery in international situation. It hasn't been in much use. My experience in it is, well, primarily theoretical, but we think we know how to use it and tell you something about the background to it. And with that, let's see here. We'll go over to what we are going to talk to you about today. This is what we intended to speak about. It somewhat differs what it says in the program, but basically we will start with giving an introduction to the regulation, who can use it and when it's applicable, and then we'll run through the practical aspects of the procedure. How does it works? It's first it's an application and an opposition from the debtor, and how is a European order for payment, or an EOP, then enforced in the other country. So, Fredrik, over to you.
Yeah, I think we can go to the first the background slide. Yeah. So I mean the EOP regulation is part of the European international procedural law, really, which as many of you probably know, kicked off already with the Brussels Convention, which was from 1968. And then that convention was translated into a regulation in the year 2000. And then from the year 2000 and onwards, followed in that wake a series of European regulations dealing with sort of cross-border disputes. There are essentially, I mean, the reasons for this, for these initiatives from the European legislator is, as was mentioned initially by the Deputy Rector, the European interest in facilitating recovery of debts in the Union. And the basis of that interest, of course, is the Union interest in facilitating the free movement of businesses and persons, and also of judgments and claims. And the general idea is basically, of course, that if it is easy to recover your money, if you do business with somebody from another country, then you're much more likely to actually go there and do business with them. And so the sort of prospects of having an easy avenue for access to justice will make you more prone to go out and do cross-border trade, and thereby sort of furthering the Union objectives of free movement. And you can do this in two ways. And the Brussels Convention and the Brussels Regulation provide sort of one of these ways. You can either say, look, you can use your Italian legal system, and then at the end of the day, you will obtain a judgment or an order, and then you can take that order, and then you can enforce it in the rest of the European Union. And that has evolved from a situation with the convention where it was, the basic idea was there, but you still had a process of exequatur, for example. When you had your Italian judgment and you wanted to enforce it in Sweden, you first had to go to Samuel here in the Court of Appeal and ask him to say, okay, you can enforce this Italian judgment in Sweden, and only after that will the Swedish Kronofogdemyndigheten, which Eric spoke of, actually go out and take my money. But then there followed a development in the 2000s where there was first a special regulation dealing with the abolishment of exequatur in particular cases, which we won't talk about today. And then there was the abolishment generally of exequatur with the new Brussels regulation from 2012. So that's sort of one road. The other road is, of course, to say, no, you won't use the Italian legal system. We'll use a European procedure to do this. And there are two such European procedures which we'll talk about today and tomorrow. And today we're going to talk about the European Order for Payment procedure. And tomorrow it will be the small claims regulation. And both these sort of are to address a particular problem, which is that if you are, the cost of litigation and the cost of enforcement can be an obstacle to enforcing claims cross-border. So therefore, you need a simple system for dealing with simple small claims. And that's the reason why these instruments have been enacted. And the idea is, of course, that that you should have a procedure which is easy to use, standardized, simple, quick, and not costly. And in some countries in the Union, there are good such procedures in place, but in some countries there are not good such procedures in place. And it is also the case that in some countries, the national procedures, the equivalent national procedures, are difficult to use in cross-border cases. So that is the reason why this regulation came into force, to provide a tool for easy access to justice. So that is the background to the regulation. There are, I mean, when it came into force, it was applicable, of course, also to the UK. The UK is gone, and now gone with some margin. So you can, unfortunately, no longer works in relation to the UK. It doesn't work in relation to Denmark either. It has never worked in relation to Denmark. Denmark, for some reason, has decided that it wants to be outside the European cooperation in civil procedure matters. But in the rest of the Union, it does work. Okay.
Well, I think we covered some of this, but so when should one then use the European payment order procedure? Well, as we have talked about, it's for cross-border cases where there are two member states involved primarily. There should be a claim for it's a pecuniary or monetary claim concerning a specific amount, and it doesn't matter what amount the claim composes. It's not like the European small claims procedure where there's a maximum limit of 5,000 euros. So you can have a monetary claim or whatever amount. And the situation should be such that the creditor does the assessment that the debtor will not contest the claim as such in a legal manner. They might not want to pay, but they don't have any legal grounds for it that they could put forward. And in these cases, the European payment order procedure is a quite good alternative to a national procedure in a foreign country, which will often be the case, because jurisdictionally there's often the case that the court or where the debtor or the defendant or the debtor is domiciled has the jurisdiction, and then of course you always have the alternative of using a national process, but that will be unknown to you and might be complicated in another language. And instead, this European payment order procedure offers one common procedure for the entire European Union. And in that sense, it's accessible. It's quite simplified as it's done in standard forms that's annexed to the regulations, so that everyone uses the same forms, basically. And it's swift in the sense that the regulation sets down, provides set timelines limits, 30 plus 30 days, basically, for a European payment order to get enforceable. And it's probably easier to get enforced in another member state than a national court order or judgment many times, as they differ. Even though they should be recognized and enforceable through the Brussels regulation, they will differ in format and appearance, which might lead the recognizing court to mistrust them or well, prolong the procedure. Anything on that?
No, yeah, I mean, I should say that one sort of practical use of this was I had a case with, as it happens, an Italian defendant and a Swedish claimant, and this was a case which was governed by an arbitration agreement. So if you go to a court, the court is likely to say, no, we won't take this on. We will refer this to arbitration instead. But the claim was basically uncontested. I mean, it was almost debt collection. And so we were thinking about, and we got in touch with the Italian council to see, what about enforcement in Italy of this. And the sort of the picture we got was that if we go to a court to do a simple debt collection procedure, then we could end up with the debtor saying, look, there's an arbitration agreement, the court saying, okay, we won't take this, and us ending up paying legal fees. And then we thought that this could actually be a good alternative, because this is a procedure that we know exactly what's going to happen, and we can say that if the debtor says no to the claim, we can say from the beginning that then we don't want to go into a national civil procedure. Then we want to discontinue the proceedings, and then we'll just request arbitration instead and go for the arbitration route. So, and in that case, this provided a rather practical way of doing it, and it's also gave the client some certainty as to sort of what was going to happen. So that's sort of a practical use of the regulation, and quite useful. Okay, so a sort of general remark here initially on the interpretation of the regulation. And as I said, this is part of the European Civil Procedure law, and like the other regulations in this field, and like the Brussels Convention before it, the terms of the regulation are to be interpreted autonomously. And that means that they are to be interpreted in the same way in all member states, basically, and that the terms are, I mean, in the end, the meaning is interpreted by the Court of Justice in Luxembourg. And this is a particular sort of aspect of the European Union law, since generally in private international law or in international procedural law, it could very well be that you have recourse to national law to find the importance or the proper interpretation of a particular term. But in this case, a lot of the terminology is not only interpreted autonomously with the Court of Justice as the sort of having the last word, it's also the case that there is a lot of terminology which is common to the different regulations. So, a lot of the terminology used in this regulation is also used in the Brussels I regulation, and so you can go back to 50 years of case law on which will tell you what the different terms mean. And in some instances, you can also go to the Rome regulations to see what the proper interpretation of certain terms are. The regulation provides for a rather sort of simplified skeleton procedure where you sort of go from lodging your application to receiving your order in the end. But it doesn't really say very much more than that. It leaves to the national authorities or courts dealing with the application of the regulation to apply its national procedural law in matters which are not regulated by the regulation properly. So if you do this in Italy, there will be aspects of the procedure which will be governed by Italian law, and if you do this in Sweden, there will be aspects of the procedure which will be governed by Swedish law. We put down on the slide here the main two Swedish laws which govern the procedure and before the enforcement agency. But that is really, I should, for you, probably of academic interest. Okay, let's go on.
When it comes to the material scope, we listed relevant articles here, and we already talked about Article 4, that is that the regulation is applicable for the collection of pecuniary claims for specific amounts that has fallen due when the application is made. So that's probably covered. You can continue talking about Article 2, I think.
Yes. Okay. So there are two limits here to the material scope of the regulation, and the first is that the claim that you're trying to enforce must be in a civil or commercial matter, and the second is that it must concern a cross-border case. When it comes to the first one, civil and commercial matters, this is a distinction which is common to all of these regulations. So, and it's in the Brussels regulation as well. It only applies to civil and commercial matters. And there is actually a lot of case law from the Court of Justice on this particular distinction. And the distinction, of course, is mainly between the enforcement of private claims versus the enforcement of public claims or government claims. And in many cases, it concerns the distinction when there is a public authority acting in some capacity where it is sort of taking over a claim or having a claim against some private individual. And then it will be a case of determining what is the basis of the claim to see whether it is of a public or a private nature. And roughly, you could say that if the claim is something, this could just as well have been a private party looking to enforce this claim, then it's fine. Then you're in a civil and commercial matter. But if it is concerns somehow the exercise of a power or a function which no private person could hold, then it's a public exercise of public authority and falls outside the scope of the regulation. In theory, this is also an autonomous concept developed through the jurisprudence of the Court of Justice in Luxembourg. But I mean, a reasonably good starting point is to look at your own legal system and see what the distinction there says, and then you can sort of get a pretty good idea of where you're going, so to speak. Then it is also the case that the regulation only applies in so-called cross-border cases. And a cross-border case, it says in Article 3, is a case in which at least one of the parties is domiciled or habitually resident in a member state other than the member state of the court. So you have it's a relationship between the court on the one hand and the parties on the other hand. And that means that you could theoretically have a case where you have one of the parties outside of the Union, outside the European Union, as if the court and the other party are within the Union and are within two separate countries. But I mean, the typical case will be where an Italian claimant is looking to enforce a claim against me, a Swedish defendant in Sweden, and is going to a Swedish court or to the enforcement agency in Sweden to do this. Okay.
The territorial and temporal scope we already covered as well. It's applicable in all the member states now, except Denmark, and it's been around since 12th of December 2008. The claim can be older than that. It just has to be a valid claim at the time of the application. So if it hasn't the period of limitation had set in. At that time, it's fine, even though it's older than from 2008. This will cross over now to going into the actual procedural rule. How does it work from application to enforcement? And this shows basically the steps of that. Basically, the process or the procedure means that the claimant and the defendant gets one shot each in a written procedure. It's not supposed to be any other exchanges of documents, and there's no court hearing or anything like that. So it's a purely written procedure. It starts off with the claimant applying to the court, which has jurisdiction in the case at hand. Maybe in this case, then, with the Italian claimant and a Swedish defendant. The Italian claimant will apply to the Swedish enforcement agency, which is a court in this aspect. Then, and then you use a written standard Form A annexed to the regulation, which is quite self-explanatory, but we'll go through it later on here. And then the court, when it receives the application, it examines it based on the information provided by the claimant in the standard form, and then the court, or in this case the Swedish enforcement agency, should issue a European payment order within 30 days from when it was launched, if there's no need to complement it or anything from the claimant's side. So it's rather swift. The issuing doesn't mean that it's enforceable, because now it has to be served on the defendant. The defendant will be served the issued European order for payment, which is done on a standard form as well, and the application, and then has the possibility either to accept or not to contest, basically, or to contest as oppose the application, and that should be done within 30 days from the service of the European order. And if the claimant, although the defendant doesn't oppose it, then it becomes enforceable, this European order for payment, and the court should declare this, and then it's enforceable in all member states. And it cannot be reviewed or changed in any way, and there can only be hinders or reviews in exceptional cases, basically. And this is what we'll go through now in more detail. I should also say, I will be in this regard, that if the defendant opposes the claim, then there's two options for the claimant, either to continue to a national procedure or the European small claims procedure, if that is applicable. And that's the basic. If you're silent as a claimant, that will happen automatically. The competent court will hand the case over to this ordinary procedure. But if the claimant has expressly stated that they want to terminate the process altogether, then that should be done. And if so, that doesn't mean that you can't start a new process again concerning the same claim. And
okay,
this is the application then.
Okay, so the first step then is to find the correct, the appropriate, the competent court, and as you will see, there is this rule in Article 5, which is basically for the Swedish case, where we don't go to a court, but we go to an authority for this procedure. I think it's the same. It might be the same case in Hungary, where they have a kind of similar situation as in Sweden. But in all other member states, these are dealt with by first instance courts. The international jurisdiction of the competent court or authority is the rules for that are in the Brussels I regulation. So you have to look at the Brussels I regulation to find out which national court or authority should I be going to. And then when you have the answer to that question, you'll have to look to the national legal system, which court or authority within the country should I be going to. But the international jurisdiction, I mean, the main rule of the Brussels I regulation is that the courts of the defendant's domicile are competent. And that's also the sort of standard situation many times that if I'm looking to enforce something against somebody who is domiciled in Italy, I will be going to the Italian courts to do that. But then there are, I mean, a number of rules, exceptions from this. The most important exceptions when it comes to the order for payment procedure is probably the rule which deals with contracts. And the main rule of jurisdiction based on contract is that the courts at the place of the performance of the contracts have jurisdiction to hear the case. And when in cases of sale of goods, it is the place of delivery. So if I buy something which is supposed to be delivered, if I buy something from Italy, and then we agree that it is to be delivered in Rotterdam, but using an Incoterm or something like that, then the courts of Rotterdam could have jurisdiction to try a dispute between us concerning this. But normally the place of delivery is usually either the seller or the buyer's place of business, and then you arrange the transportation between you. When it concerns services, contracts for the provision of services, then it is the place of performance of those services. And then if it's neither goods nor services, you have to look at sort of to the contract and see where is it going to be performed. And if the contract doesn't give you the answer, then you have to look at the applicable national law to see what the applicable national law says about the place of performance. The other big rule in the Brussels I regulation when it comes to jurisdiction is the rule on jurisdiction in tort cases. So acts of non-contractual acts of delict. But most of that is excluded from the application of the order for payment regulation. So it's not, in most cases, will not be relevant. And to some extent, that is probably good because those rules are the most sort of expansive rules. Those are rules where you can sort of find jurisdiction a bit, I mean, potentially in some cases in many places. There is a particular rule relating to consumers. And it says that when a consumer is a party to the case, and it is the defendant, the consumer is the defendant, then it is only the courts of the member states in which the defendant is domiciled that are competent to hear the case. Then there are also, I mean, special rules in the Brussels I regulation on jurisdictional agreements. For example, if you have concluded an agreement that the courts of one member state, particular member state, should be competent, then that is also a basis for jurisdiction. Then there are particular rules relating to contracts of insurance and so on. Oh yeah, and the Commission has a pretty useful homepage where you can go in and find information about the different national legal systems and to find out where you should be going if you're going to Sweden, for example. What is the authority and how is it done, and so on. So that is recommended. There's all sorts of useful information apart from that.
So now you've found the competent court, and now you just need to fill in the application and send it to the court that has been designated by the member state in question. And what information should be provided is stated in Article 7 of the regulation. And it's also, as we said previously, it's a written procedure and it's based on standard forms. And when it comes to the application, it's mandatory to use the standard form where there are a lot of pre-printed information, basically, and you fill in some of those and tick different boxes in other cases. What it should contain is then the amount of the claim, including interest. The claim should, as we said earlier, have fallen due at the time of the application, and it should be for a specific specified amount. Then you have to provide details on the interest on the principal claim that you want to get. And when it comes to that, it could be sufficient to state that you want interest in accordance with a statutory interest rate that follows from the applicable national jurisdiction. And when it comes to interest, it doesn't have to be a specific amount. Then, of course, it can be open-ended in the sense that it's interest until payment of the debt. Then you have to specify the course of action, and including a circumstance description of what is invoked. This can be rather short, as this is standardized procedure. Basically, the purpose of the amount of information you must put there is so that the applicant can understand what type of claim you are talking about and know if he or she should accept or contest the claim that has been made. So there should be enough information so that they can make a well-informed judgment there. And also, of course, enough information so that the court could do a prima facie evaluation whether the claim is clearly unfounded. But that, of course, takes a lot in order for it to be clearly unfounded. And also, because the regulation doesn't specify the amount of information, but if you look at how the the standard forms have been made up, you can see that there's relatively little information that has to be there. It could be just information, claim concerning the sale of commodity X for the price of Y at this date for this price, basically, would be enough. In many cases, and then you can just fill in a description of the evidence that you have. You don't have to annex them to the application. It's sufficient to describe it, because this is not supposed to be a evaluation of the facts of the case, but basically so that the applicant knows what type of claim or what the claim is. Because if it's opposed, of course, it will continue in a national procedure, a regular one. The competent courts, well, as we said, they are decided which competent. When you found the right jurisdiction, you'll have to find which is the competent court, and that type of information is publicized, as Frederick said, on this e-justice portal by all the member states. So that's where you find it. And in Sweden, of course, as we said, it's the enforcement agency. And then you submit your application. It's mandatory for all the member states to accept it in paper, and it can also be sent in electronically if the member states accept it in that way. And when handling this procedure, it's not mandatory to use a lawyer, or the whole purpose of it is that you shouldn't have to use a lawyer, because it should be so simplified. If you decide to use a lawyer, well, it's possible to ask the debtor to pay compensation for the fees for the lawyers, but probably they can't be that big, as the standard forms are quite self-explanatory as such. So, and well, you have to fill it in the language, of course, that the competent court accepts, or the member states addressed accepts, and that can also be checked on the e-justice portal. It's different in different countries, but this is something that could be an obstacle, in the sense that there are so many languages of the European Union, but that's when the standard forms comes into play as well. It's quite little information that has to be provided, and it can be quite easy to translate the information.
After having submitted the application to the court makes an examination of the application, and it makes an examination in two respects. First, it's a formal examination of sort of going through all the requirements that Samuel just went through before the break in Article 7, looking that all the information is there. And then second, it makes a summary examination of the grounds for the application. That does not mean that the sort of court, in any sort of normal sense of the word, tries or takes a position on the merits of the case which is brought. But it does make a check that the claim does not seem to be obviously unfounded. It should also make a sort of a brief check on jurisdiction that does not seem to be obviously wrong. When in the case that the defendant is a consumer, there is a case from the Court of Justice, case number C453/18, which concerned a Spanish court which had received an application for an enforcement order against a Spanish individual concerning a loan, and in that case, the Spanish court concluded that it was a consumer case, and it was concerned that the terms of the loan agreement were unfair to the consumer. So it asked the applicant to submit further documentation on the question to show that the terms that were being enforced were not unfair. And then the question came up because the applicant said, there is no basis for you to do this. I have submitted everything needed according to the regulation. You can't sort of ask me to submit anything else. And the question came up before the Court of Justice, which said that, well, normally that would be the case, but in the case the defendant is a consumer, it is perfectly permissible and also required by that the court should make certain that unfair contract terms are not enforced against the consumer. Yeah. And in terms of the sort of the ordinary check on whether it seems to be manifestly unfounded, this is really a very a brief examination. It says in recital 16 to the regulation that this is something which can be entrusted even with somebody who's not a judge, and it can even be an automated process. So the threshold here is really low. If it is the case that after having examined the application, having reached the conclusion that it does not seem to be manifestly unfounded, but there are formalities lacking, then the court or the authority can request the applicant to rectify the application, and then that is done on a standard form B. It can also be the case that the court could propose to the applicant that the applicant should strike out some of the claim after having the court having made an initial assessment that that part of the claim is not something which could form the basis of an order. And so the court can give a proposal to the applicant that we suggest that you keep this part, but you strike out this part. And then in that case, that's done on another standard form C. I would think, though, that in many cases, for practical reasons, certainly in Sweden, what you would expect is that the authority would probably call the applicant and say, look, we've seen that you've done this. Could you just submit a new application? Because that could actually prove a little more practical than this this business with the form C. If you don't do what the court asks you to do to rectify the application, or if you reject a proposal to strike out parts of the application, then the court can reject the case, reject the application. And if not, if the applicant does what he should do, then the court will issue an order on standard form E. I probably should be added here that there is a case from the Court of Justice, case C215 for 11/11, where the question came up if the grounds for rejection of an application, as stated in the regulation, are exclusive or if you could also reject the application on the basis of national law. And the Court of Justice said, no, the grounds are exclusive. The only basis for rejection of the application is are the grounds set out in the regulation. So you can't say no on the basis of your own national procedural law. Yep.
So now the court has, after reviewing the application, has issued an European order for payment. And then the next step is to service it on the defendant. And what the court does is that the court fills in a standard form G, I think it is, and attaches the application by the claimant to it, and then has to service it on the defendant. And this is a formal requirement in order for the EOP to become enforceable. And the service of these documents is done in accordance with national legal rules, but in order to well, the regulation, it contains minimum rules that has to be fulfilled in order for the service to be valid. So it's national laws that apply, but some minimum rules has to be fulfilled. And basically there are two methods of service of documents. It can either be service with the proof of receipt by the defendant, or the defendant's legal representative, or there can be service without proof of receipt of the defendant or his or her representative. And they follow quite specifically from the regulation which methods are allowed. Basically, either you can have it served personally on the defendant, and he or she signs, thereby acknowledging the reception of the documents, or it can be handed over with a declaration from the person handing it over to the defendant, stating that they refuse to accept it without having any legal ground for the refusal. And it can also be sent by post and signed by the defendant, and where it's possible, electronic service is also okay. And when it's service without proof of receipt by the debtor, there's some possibilities there where you can service it on persons living in the same households or employees of the defendant. And here also there is of course another regulation, EU regulation concerning the service of documents, which has to be fulfilled. And one important aspect of that is that there is a right to refuse to accept documents that is being served if it's in a language that you don't understand, or if it's in a language that is not official language at the place of the service of the documents. So in these cases, there is a possibility to refuse the service of the documents. And to this service, there also has to be information provided stating this, that is, you have the right to refuse to accept it. And the lack of that is a lack of the formal requirements of services, which has basically the same effect as if the documents were not served with you at all. So in both cases that will have effects. Then there's however, some strange case law from the European Court of Justice on this matter, as they seem to have found the conclusion that first in this eco cosmetic case that if the formal requirements of service are not fulfilled, that is something that cannot be used in an application for examination under Article 20 of the regulation, which we will discuss later on. And this is one of the, because according to Article 20, there are some exceptional circumstances when a European order for payment can be reviewed. And lack of service is, according to the European Court of Justice, not such an exceptional circumstance. And not the same is the case when the defendant hasn't gotten the information that they have a right to refuse to accept it. And that was found by the European Court of Justice in a later case called Catlin, I think. The problem is that the European Court of Justice also in the later case states that in such a case, then the European order for payment is not enforceable at all. So it's basically null and void. But there is no procedure within the means of the regulation to establish that fact. Instead, you have to use a national procedure, which if there is such a remedy available where you can attack the European order for payment for a gross procedural wrong, basically. So this about the service on the defendant. Okay, so then the defendant, let's say that he or she now has been served. Then there's two options for the defendant. The defendant may either lodge a statement of opposition to the order for payment, or not oppose it, either accept it or not answer at all. And the effect of opposition is that the proceedings, as we talked about earlier, shall continue in accordance with the ordinary private law procedure, either in accordance with national procedures provided in national law, or in accordance with the European small claims procedure. They can choose that as well from the claimant's side. But of course, as we also said earlier, the claimant always has the opportunity or the possibility to ask the court to stop the proceedings if there is an opposition, because the claimant might think that it's not, well, they don't want to start a procedure with all the costs that's involved. They just want to test the defendant's willingness to pay, and then they can just terminate the procedure. But it's important for the claimant to state this explicitly, either in the application from the start or at a later stage, but before the court actually declares that the European order for payment is enforceable. I should say something about, yes, the lodging of the statement of opposition. It's stated in Article 17 that it should be, or 16, that it should be sent within 30 days of service of the order. So the defendant has 30 days from the date of reception, from the date of service of the documents, to lodge his or her statement of opposition. But there will be a question for the court because they have to allow the relevant time periods is when it's sent. And of course it takes different amount of time in order for the postal services to do their job, maybe, and the court before declaring the EOP enforceable must take into account that it allow the opposition to appear, basically. So that might cause some confusion. And well, it's quite evident, but the European Court of Justice in I think Novotech versus Logidata case C324/12 established that it's not an exceptional circumstance which allows for a review of the EOP that a lawyer miscalculated the time span, basically. In the case, a lawyer miscalculated with 1 day, but okay, then it's too late. Let's see, I had something more to say here, but concerning the enforceability. And we have started to take up this question as well. When if the defendant hasn't opposed the EOP within the time limit, then the court shall declare it enforceable. And the effect of that, of course, is that it's enforceable in all EU member states. So we continue with the enforceability.
Yeah, and this is just to repeat actually what you just said. I mean, it's obviously enforceable in the member state of origin, in the country where it has been issued, although it is a European instrument, but it is also recognized and enforceable in all other member states, except Denmark then, without the need for a particular declaration of enforceability. And there are, as we shall soon see, extremely limited possibilities of opposing the recognition and enforcement of this order. However, there exist a couple of options for the defendant who believes that this order has been entered into unjustly against him or her. One is to apply to the court of origin, which issued the order for payment, for a review of the order. The other is to impose the enforcement in the country where enforcement is being sought. And there is actually a third possibility, which is to use national procedural law to complain about the fact that you weren't properly served. This option doesn't follow from the regulation, but follows from case law. I don't know, maybe I should. Should I say no to this, Sarah? There is.
No, you have to say no.
Yeah.
Yes, please.
Okay.
Thank you.
Okay, but we'll start out with the review, the possibility of review. There is no general possibility to sort of appeal a decision for an order of enforcement. The only possibility is really this very limited review, which follows from Article 20. And it also follows from the case law of the Court of Justice that these possibilities should be used restrictively. So, and that is a case C245/14 called Thomas Cook. And the first one is where the defendant did not have enough time to prepare the defense. And there is a reference here, which unfortunately is not on the slide, but which is in the regulation to Article 14, which means that it's only where service has been effected in accordance with Article 14 that this applies. And this is service without proof of receipt. So those cases where service has been made in that case. And I mean, considering that you don't really have to motivate entering into an opposition to an order, it doesn't really take all that much time to sort of prepare your defense. So I would think that sort of the time needed here to prepare your defense, which the regulation speaks of, it's not all that much time. I would say that it's probably enough to be able to understand the claim, to check whether the claim is founded or unfounded, if there are any doubts regarding that, and then to sort of make up your mind whether you want to say no or yes. So I would say that probably a very limited amount of time. Then there is also the possibility to object by reason of force majeure, extraordinary circumstances. And there is I mean, the example which is given by the European Commission in their handbook concerning the application of the regulation is that you've been hospitalized, for example. It's not okay to say that your lawyer failed to enter an opposition within the prescribed time. That was tried in one case, case C324/12, and you can't get a new procedure on that basis. There is a further requirement, and that is that you should act as soon as practically possible when if you want to make use of these opportunities for review. There is furthermore the possibility, and that's under number C on the slide, where it was clear, where the order for payment was clearly wrongly issued or due to other exceptional circumstances. Now, as Samuel already mentioned, this came up in a case C119/13 called Echo Cosmetics, where the defendant argued that it had not been served properly with the application, and therefore that it should be set aside on this basis that it was wrongly issued. As Samuel also explained, the Court of Justice, in my very humble opinion, in a slightly sort of formalistic turn, said that, well, it was not wrongly issued, but it hasn't been issued at all since the service was not properly effected. So there is really no order for payment to oppose. And this sort of slightly bizarre result of this is that you can't have a wrongly issued on the basis of no service application set aside using the regulation. Instead, you have to apply national legal remedies dealing with sort of similar problems. It is unclear from the case law of the Court of Justice whether this is something that you can only do at the court in the member state of origin, or if this is also something which you could potentially do in a member state where service is being sought. I mean, clearly wrongly issued, what could it else mean? I think what has been said is that it could be the case where the information which was provided by the claimant or the applicant was false, for example. So in a case of fraud, almost, I mean, the applicant using the procedure as a means to sort of defraud, I guess, both the court and the defendant. But it's not a sort of a general opportunity to review the case on the basis, for example, that we think that the legal basis here is weak or something like that. But if you lie in your application form, then this could possibly be a ground for review. Right. So if there is no review and the order is not then set aside, then it will continue to be valid, and you can take it to another member state to have it enforced.
No? No.
Okay.
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 So now you decided to take your European order for payment to another member state where maybe there are some money to collect. And Article 21 of the regulation then state that well, first of all, it's now enforceable without, as we said, any exequatur measures or any declarations or anything from the member state addressed. The member state addressed should enforce it in the same way as a comparable order or judgment from that member state. So no discrimination is allowed. But the procedure as such is governed by the national law of the member state as such. And the creditor has to provide a copy of the European order for payment, and if needed, which will often be the case, a translation of it into an official language of the member state that is addressed. That is, of course, so that the member state addressed can read it and enforce it. It doesn't have to be an official language of that member state. Each member state is allowed to decide for themselves which languages they accept. So, for example, in Sweden, it's possible to do it in English, I think, and maybe some other languages like our minority languages like Finnish and also Danish and Norwegian we are supposed to know as well, even if we don't really. But that's the way it is. And then you have to find the right, so you have to check which languages are accepted, and that you can do on this e-justice portal that we talked about. And also there you find which authority is competent to receive their application for enforcement. And in Sweden, that would be the enforcement agency once again. So now it's in.
Yeah, and then, as I said, there exists also the possibility for the defendant to apply in the member state where enforcement is sought for refusal of enforcement, but it is the basis for doing that are extremely limited. I think you can just note that even sort of basic notions like ordre public are not applicable. So even if this should be enforcing this should be contrary to ordre public in the country where enforcement is sought, you should not refuse enforcement. The only ground for refusal which exists under the regulation is if you have a res judicata situation, i.e. where there is a previous judgment or order which is irreconcilable with the order for payment. And at least according to the Brussels I regulation, and this applies, I'm sure, on this regulation as well, the res judicata effect of a judgment is determined by the national procedural law of the country of origin. So the res judicata effects of a Swedish judgment is determined by Swedish procedural law. And if you recognize a Swedish judgment in Italy, the Italian judge must understand what is the res judicata effect in Sweden of a Swedish judgment to make that assessment. But as you see, there is also a timing aspect of this ground for refusal. So it must be an earlier decision or order previously given. I've actually tried quite hard to understand this rule and tried to sort of think up in which situation, practically could this become applicable, and I really find it difficult to understand when it would be applied, because there is a requirement in Article 22 concerning the refusal of enforcement that the irreconcilability, which is the basis of not enforcing the order for payment, could not have been raised as an objection in the court proceedings in the member state of origin. So this must be a really sort of weird timing aspect here for this to work, and it seems to be almost purely theoretical from what I can see. But as I said, in addition to this, you probably have this, Court of Justice introduced possibility of saying that service was not effected properly, and that you could use national law to address that problem. It is unclear whether that's available at the refusal stage or only before.
So another way for the debtor, the defendant here, to hinder, if only temporarily, the enforcement of the EOP, that is linked to the process of review in the state of origin. So if the defendant has applied for a review in the state of origin, then the defendant can also apply in the member state addressed where enforcement is sought. The defendant can apply there for a stay or limitation of enforcement of the European order, and that is regulated in Article 23 of the regulation. And in these cases where the defendant has applied for a review in the state of origin, then the competent court in the member state addressed may make one of these three, has these three alternatives. The first two, of course, means that enforcement continues, but are limited. So in the first instance, the member state addressed may limit the enforcement proceedings to protective measures, or second, they may make the enforcement conditional on the provision of securities from the creditor, that the creditor provides securities. And then as a third alternative, only on the exceptional circumstances may the competent authority of the member state addressed stay the enforcement proceeding as such, meaning that there will not even be protective measures or enforcement with securities. So that's a very, very narrow thing, and also, of course, it's only temporarily pending the decision of the court in the state of origin on the review, if it's accepted or not. And there it is.
Yeah, I mean, I think we've reached sort of the end of the procedure by now, and hopefully the claimant has got his money. As you see, I mean, it's a pretty straightforward procedure designed for simplicity and speed, and should be rather useful in these cases. In reality, I think, as we concluded, it is quite seldomly used. Maybe because lawyers are conservative, or it may be because there has been not enough publicity on this. Yeah,
the Swedish statistics are speaking its own language. I asked the enforcement agencies for numbers of the number of applications for a European order for payment, and it's for 2020 was 350 in total, and that was the highest number ever. It's gone up over the last 3 years from 150 basically, and that can be compared to the number of Swedish order for payments that's sent in each year, which is 1,200,000 towards physical persons, and then an additional 200,000 when it concerns legal persons. So 1.5 million compared to 350, and still, of course, we are a country which has cross-border trade, so one would assume that there would be a market for you using the EOP. However, I think that one explanation could be that, well, we have primarily, or the biggest numbers of trade with our closest neighbors from the Nordic countries, maybe Germany, and it's well known on each other country's national procedures and the national procedures for order for payment. So it's and there's a mutual trust between the competent authorities or courts. So it's not that problematic to use. So even if it's in paper, it's quite well drafted and easy to apply. There shouldn't be too much confusion, except for the confusion that we claim has been created by the court when it comes to the service of documents, maybe, and the review of those. But of course, it's well. Does a tree in the forest without a sound make a sound?
Yeah. I mean, I think my impression is that it varies across jurisdictions in Europe how much this is being used. What we heard, which I thought was quite interesting, was when we had a similar exercise in Sweden. In Swedish, there was a judge who was from Gothenburg, and he said that there was a sort of claims enforcement company which had discovered that this was a useful tool, not least because the opportunity to refuse enforcement after you have the order are basically null. So if you use the Swedish equivalent, for example, even if you have, after you have your order, the debtor can apply to have the order reviewed, and if you do that, you start all over again. But under this, once it's ordered, I mean, you're basically done, right? So from that point of view, it was quite useful to them, I think. So they had sort of taken note that this could be a good alternative, and for that reason, I think they were incorporated in a different country, so that they could, use this in Sweden, despite, and so they put themselves in, I don't know, Denmark or England or whatever it was. to be able to use the procedure, which is also an interesting sort of development that some debt collectors have taken note of this. Thank you very much.
So thank you very much, Fredrik and Samuel, for this amazing contribution to the study of the EOPP. Now I leave the floor to Marie Linton, that is an associate professor in private international law and international civil procedure, vice head of the Faculty of Law at Uppsala University, president of the Swedish Association of Comparative Law, and member of the International Academy of Comparative Law. She is working on these topics since a lot of time, and he has a big research project on the recognition and enforcement of foreign judgment under Russell I regulation. So please, Marie, I leave the floor for the question time.
Well, thank you so much, Sarah, for hosting us and having us here. And thank you, Samuel and Fredrik, for this enlightening speak about the EOP. And I just want to open up the floor for questions to the speakers. And I know we have one urgent. Marta, I know you have a few questions.
I actually want the question to you. Well, actually, they were more a curiosity, and I guess I have two curiosity and one question. Okay. So the first curiosity, a general one, is about, and it's related to the numbers you mentioned at the end, the statistics, and it's in order to try to understand why, another possible reason why the procedure was not particularly successful in Sweden. And I was wondering, how far is the regulation from the Swedish national rapid enforcement of credit procedure? So
it's quite similar.
It's quite similar.
Yes, it's quite
okay,
similar.
so that's amazing. I thought, it would have been an easy answer if they were very different, and then we could have explained a sort of inertia of professionals and judges in not wanting to learn a new procedure, but if they are similar. So I drop. You answer, and I dropped that question.
But how is it in Italy?
In Italy, it's different.
It's okay.
Yeah. In Italy, it's quite different, and that might be one of the reasons that actually explain why we have difficulties with something that it's far away from what we usually do. The main difference for us is that we need a lot of document. So the creditor need really, to persuade the judge that he has a very good claim. It's not enough a form where he states, I have a claim and this is the contract and I want 2,000 euro, but it needs to produce a lot of evidence. And so there is a sort of pre-evaluation, even if inaudita altera parte by the judge in the ordinary procedure. And that's why judges, they don't really trust the European one, because it's unbelievable to them and to lawyers as well, that you can simply file a form and then obtain an injunction. Anyway, that's Italy. My second question was for you related to the court service. Did I understand correctly that in Sweden, it's the court that serves the documents, so the court itself?
No.
No. Okay.
Well, it's a court in the sense of the European the Swedish enforcement agency that serves the documents, but they can use a private company to do it.
But the point is therefore that the costs are borne by the enforcement agency. That was my question. Yes. Okay, because in Italy, the court, we don't have the enforcement agency competent, we have the court. Will never serve a document. I mean, the document is there, and then it's up to the person who asks for that document to go and check whether the document is ready, take it and serve it.
Do it.
Even if the regulation said the court, the regulation is quite...
So not only pay for it, but also...
Exactly, also take care of it, correct. Yes, take care and pay.
Well, there's a possibility in Sweden to do the service in some cases by yourself as a creditor, but that's quite.
The main rule is that the court.
Yes, the
okay.
problem. Sorry, I don't
sorry.
know. Sorry, I tried to move that.
The main rule is that the court or the enforcement agency will effect service, right? But if it doesn't work, then the court can ask the claimant, if, do you want to try?
I see.
Do you want to have a go at serving this
Pay more,
person
find a good postal.
who is, and sometimes you can, because the court service process is a little slow.
Yeah.
If you want to serve somebody quickly, you can ask as a claimant, could I please serve this myself? And then you can do that.
I see, but it's an option. I mean, it's not
an
a,
option,
yes.
yeah.
While for us, it's either like that or the document will remain in the court forever, because it's like your burden as a claimant to take care of everything, including, checking when it's ready in service. Okay, great. And last question, it was for you about the wrongly issued requirement under Article 20, I think, which, well, because you made the example, I understand it's very difficult and very hard to interpret it, and you made the example of the claim, the applicant who lied. And then I was rereading Article 20, and I noticed that to ask for a review in case in which the European order for payment was wrongly issued, the article does not say that the person who's asking the review should have, he cannot ask the review unless he had the possibility to challenge before the order of payment. In the previous paragraph, they said there is the right to review, but nobody can ask the review if they had the occasion to lodge a complaint and they did not. That's the beginning of Article 20. And that's the second part who said you can also ask for the review in case of a wrongly issued order of payment. Okay, fine. But there they said nothing about whether it's important or not that you had the occasion to lodge a complaint. So my question, because my immediate reaction to your example of the wrongly issued order of payment because of a lie of the applicant was, well, but the other party could have lodged a complaint if she did not. How can it be possible that then lie afterwards is a reason for asking the review? Okay, so that was my first observation, but then I reading the article, I had the new problem of understanding whether or not it's important, according to you, for that reason of review, whether or not the person asking for the review had or not the chance to lodge a complaint. I don't know whether, I know it's very complicated. Was I able to make my case?
Yeah, I don't know. I think there are two rules, right? One is under the first paragraph of Article 20, and the other rule is under the second paragraph of Article 20. And the rule of review on exceptional circumstances clearly wrongly issued, the clearly wrongly issued ground, that's the second paragraph.
Yes.
And as I read that, there is no particular requirement in that paragraph relating to, having made had and sort of not used the opportunity before to contest the claim. So
that means that it doesn't matter.
No, I think so. Yeah.
Yeah, which is kind of.
But I don't think it would be sufficient that that would be any lie as such. It has to be reach the level of clearly wrongly issued. So it's comparable with exceptional circumstances.
You probably have to qualify lie a bit, because in many cases the parties think that the other parties are lying.
Exactly.
But it's just the sort of the banal theatrics of a dispute. So that doesn't really work, I don't think. But it has to be, you have to sort of really establish that this was fraud, that this was fraudulently, so probably intentionally wrongly.
And it doesn't matter, according to you, that you had the occasion to notice it before and you didn't, persuade the judge, because there is always.
I
don't think so, because it doesn't say. And if you have a situation where it's a sort of qualified wrongdoing by the applicant knows that this is untrue and still submits the application, then I think that's a pretty. That would probably.
It cannot be superseded by the fact that the other party. By the other party's failure to lodge a complaint. That's what you want to say, like malafide.
That's my reading.
I see.
Another one would be also that if the court failed to reject the claim because it was clearly unfounded, because the court should examine it and only issue an order if it's not clearly unfounded. Well, that is sort of an equivalent of was clearly wrongly issued in some cases. So the court was wrong to issue the European order because it was clearly unfounded, but they didn't see that until afterwards. So the defendant will then contest it in the review, stating this.
But the defendant had also the occasion to contest it before. That's my problem. So,
but if it was clearly unfounded already, on a legal basis, for example, that it's basically based on Pactum Turpe or something like that.
But I think you could also have it could be the case if you have a consumer as a defendant, and you know the rule for jurisdiction is that it's a mandatory forum, the consumer's forum. So if you go to another court, then the consumer's home forum, domicile, and that court accepts jurisdiction, which it shouldn't do, and issues the order, then that I could think could probably qualify in this case also.
Yes.
Because you know the main rule that if you don't dispute the jurisdiction of the forum, then you accept the jurisdiction of the forum. That doesn't really. I don't think that will fly in a consumer case.
No, because it's a mandatory jurisdiction. I
So
guess
that could be another case.
No, there was a case actually where I can't remember the name of the case, but where the European Court of Justice said that, well, it's for the consumer to decide whether or not he wants to dispute on the merits or dispute the jurisdiction as well. So that means that we call it silent prorogation. That supersedes the consumer special jurisdictional rules.
So thank you a lot. Sorry for insisting that much, but I had the doubt about what to do with the failure to lodge a complaint and whether that allowed the review. So now it's back to you. Many thanks.
Thank you. And I leave the floor open for questions on Teams or here in Sala Atti. Bravissima. We have Natalie, please. Yes.
Thank you.
I think you should.
Okay, it's a very simple question, but I will count for you so everyone can see me. Okay. Thank you. And just like for the record, I'm not part of Uppsala faculty. I'm also a law student, so I can make very simple questions, so which I will do now. So as I understood it, you said that the European payment order is not at all used in Sweden. You said it's 350 cases per year. And then I kept thinking, but like what is happening with these claims? Because people tend to like to get paid, and we have so many trans-border transactions. So then my question would be, I have like very little experience from Swedish courts, but when I worked at the district court in Stockholm, which handles cases that come from Kronofogdemyndigheten, I have done some registrations of companies in Germany, for example, that have chosen to take the procedure to Swedish courts. So my question is that, is this what happens instead of issuing the European payment order, or does people just don't get paid?
I think they use the Swedish national procedure, either a Swedish order for payment procedure, or go to the court and issue a regular application for summons.
Yeah, because then you could wonder, I mean, if you have a very large company, then you might have different juridical they can have the competence to use like all different European court systems. But if you don't, it must leave small companies and also private persons in a very like vulnerable place for getting paid. but the
Yeah.
system is there. So
Yeah,
Well,
but it's not.
it's not
that,
huge.
that used, and I don't think people will. If they're a small company, they will not try to get their money. But the only solution or the only explanation must be that they use some other means to get their money, and the means that's available is the Swedish national procedures
Yeah.
for it.
it's very serious.
And it's quite easy to apply for. You can do it
Yeah.
for the Swedish national procedure. You can just, go to the web page of the enforcement agency and fill in that form. You can do it in English, and it's a very accessible procedure, which makes it less attractive to use another one.
Maybe that's the case.
If you have continuous trade with Sweden, which will probably be the case as you're not getting paid.
Okay, thank you.
I think so.
Yeah,
But I
or
don't-
maybe because we are many law students here, we can all become lawyers who work with issuing European payment orders,
Yes,
and we
we can
can
start a
fix the
specific
situation.
company just
Yes.
focusing on that.
Thank you.
Yes. Yes, and I'm going to ask people online, do you have any questions for Samuel and Frederick?
Everything was crystal clear.
Yes,
Perfect.
good. And anyone here in the audience? No. Then can I ask you, or make some reflections rather? Because Frederick, you said that the public policy, the ordre public, you cannot refuse to enforce an order because of ordre public. There are some writers, researchers that claim that although these EU instruments does not contain a public policy clause, there is always an implicit public policy clause that you could revert to if you need it. And what is your opinion on that?
That's I mean it's a very good question, but I think that it's a question which is probably, in my view, unlikely to come up because I mean in the Brussels I regulation application of the ordre public concept. It's of course been mostly a procedural ordre public conception, which has been the basis of those very few cases where you've said that an ordre public objection could possibly be sustained. In this, with the application of this regulation, the room should be even less for doing that kind of argument. I mean, it really, I think it really boils down to service, as we've been discussing today. That's probably the main thing here, and with the Court of Justice saying that you always have the legal remedies available to you if you want to say that you weren't served properly, then that's probably sort of a safety valve in this case, which will prove sort of a good exit. In terms of sort of substantial ordre public, saying that this contract concerns something that our legal system could not conceivably enforce, the kind of obligation that I've passed, then I think that, if such a case should come up, I think a lot of judges will say, this doesn't work, you can't have that. And so they would read some kind of implied term into this, saying that, that there have to be limits. If it's, something criminal or it's really sort of really bad,
like
then,
punitive damages or something that is...
punitive damages, I don't know. I mean, that's...
Well, it varies, depends on.
That depends on, how you feel about punitive damages. but I mean,
In Italy, we have case law against the punitive damages,
Yeah.
for public poverty, policy reasons.
And France.
Okay, we have a question from the chat.
Okay.
Yes, but
Okay.
then we need to translate the question.
Yes. Okay. Okay. Thank you. Thank you.
Mm.
And you mentioned the name of what? You mentioned the name. Okay. But I because I can read it. Is the chat there? Can I read it from there? They can't. No, it's in. Yeah. You can open it. Yes, yes. I open. I read it. I translate. I try to translate it. Might be that my
Should I
translation
move?
makes it.
No, stay here.
I don't do anything. Here, there it is. So the question is from a lawyer, and the question is the following. Do you think that the cost of applying for an EOPP in Sweden is adequate? I mean, is reasonable as compared to usual Swedish procedural cost? Because the lawyer who's posing the question tried to oppose a European order for payment procedure in Italy and found out that the procedure was very expensive.
Oh.
So
In Sweden, as it's stated in the regulation, the court costs shouldn't be higher than for an equivalent procedure for a national procedure. So in Sweden, it costs as much as it does to apply for a Swedish payment order.
Which is 60 euros.
60 euros. So the court fees in Sweden are generally not that high; they're quite low, and we have dutifully implemented the European rules on this and apply the same costs.
Mm-hmm.
But I suppose it can differ between states because what is the limit is what the national rules says on comparative cases, basically. So they can't be discriminatory, but it can be high. If court costs are high, then it can be high in this regard as well, I suppose. Even if it's very, very high, it could be a claim from the European Union that it's impossible to use the regulation, of course, but that would be quite theoretical.
Right. Yes.
I guess his answer maybe.
Okay. Thank you very much. Any additional?
Maybe a comment or a curiosity that I might add, more probably for the interest of our students than for lawyers, I suppose. But in any case, just a reflection about something that when you read this regulation concerning civil procedural rules at European level, when you read the rules, they seem crystal clear. For instance, you have been explaining the rule concerning the scope of this regulation, and it was written very clearly that non-contractual obligations are out of the scope of this regulation. The main example is tort law, claims arising from tort law, but there is also claims arising out of unjustified enrichment, which should be included in this exception, and then the regulation should not be applicable to them. And it is how it is interpreted in Italy. Claims arising out of unjustified enrichment are not included in the scope of the regulation. I've been discovering through reading that if we go to Germany and we see how German case law under the direction of German doctrine has interpreted this clause, they do apply the regulation to claims arising out of unjustified enrichment, because the role of unjustified enrichment in this system is much stronger than in Italy. And they use it very much when there is a problem, a litigation concerning delivery of goods within contracts for the sale and supply of goods, movables, tangible movables, because it can happen that a restitution should brought about, and this restitution very often happens not through normal contractual claims, but from claims out of unjustified enrichment between the parties of the contract, because of how the structure of the transfer of movables is built in this system. So it might be tricky when we go abroad and we try to apply this regulation abroad. What seems to us crystal clear, like the scope of application of this regulation, might not be. So easy. So we always need to check how case law and legal doctrine apply the European regulation, even on points to which we think there is no problem at all. So easy points. This is maybe tricky, but even the different role of some institutions in private law can have an impact on the way this regulation is applied. So new differences arise when it comes to application of European regulations, depending on different legal culture and depending on how the legal institutions of private law are built in these systems. So the transfer of movable system in Germany is very different than we find, different from those that we find in France or Italy. And this can also have an impact on the scope of application of this regulation on civil procedure. So very different topics, but how much it is connected, private law with civil procedure, also at European level, and it is something that we have to consider and to always bear in mind in order not to find, not to make assumptions. Yes, wrong assumptions.
Yeah, but we can infer from your slide that therefore claims for unjust enrichment are not very common in Sweden, right? Because
exactly. Not even in Italy, we don't use it in the context of the sale of goods, cross-border sale of goods, but in Germany they use it a lot. So it's very important to notice, especially for the area in the north of Italy that have something to do business with Germany, for instance. Okay, that was. Okay. Okay. Marie.
Okay. Because if there are no further questions, I would warmly like to thank you, Samuel and Frederick, once more. And thank you to all the participants during this session. And I close the session now. Okay?
Yes, we have
yes.
a conclusive remark.
Yes, okay. Okay. Thank you.
Thank you. Thank you, Marie. Thank you, Marie. I would like to leave my seat. You could teach private international law in Trieste for my students. However, now we have conclusive remarks from Dottoressa Roberta Bardelle, judge, Italian judge. We too have a judge here connected by Teams. She is very busy, and we thank very much because she's busy with the Italian reform of the civil procedure. And she's seconded at the legislative office of the Italian Ministry of Justice. Please, Roberta, I leave you the floor.
Good evening. Can you hear me?
Yes.
Yes. Thank you. Thank you to Professor Sara Tonolo for this invitation. Thank you to the organizer of the project. As Sara already said, I am at the moment seconded at the legislative office of the Ministry of Justice, but I've been a civil judge at the Court of Trieste for around 10 years, so that's why I'm really glad to be here, at least, of course, in a digital way, but at least closer to Trieste. And then I have been seconded at the office for the judicial cooperation in civil matter for 4 years. I was head of the office until 2020. That's why I had the chance to deepen the knowledge on this type of European procedures, and that's why I accepted this invitation. I still am involved within the legislative office with international matters, but still there is the civil procedure reforms and many other matters. So it's not the main topic, but still very interesting and important for our country. Well, I'm being asked to take the conclusive remarks, but I would like to share a presentation with you to have an insight of the future of the judicial cooperation in general, and also in relation to this type of procedures. So As I said before, this seminar has been really interesting. We had an insight on the different or cultural differences between Sweden and Italy. And what I found particularly interesting is the number of professional judges. We heard we have less judges in Italy than in Sweden. And that's why the length of proceeding is different. I mean, we have 60 million of citizens and such a small number of judges. But it's really interesting to have this kind of data. And we had also a deep overview of the functioning of the European Order of Payment Procedure, the main feature, the background, the material scope. And also it was really interesting, the debate where we all realize, and I can tell you I've been contact point of the European Judicial Network for several years, and I can tell you that in all the European Union, the application of this procedure is still quite rare. But I would say that it's not a matter of trust of judges, as I said, or a confidence of lawyers or practitioners. The main issues is I think, is the complexity of international legislative instruments and rules, national, private, international rule. The combination and the framework is still very complex. That's why the confidence is still not good enough, and there's a strong need to discuss. So this seminar is really important, but also digitalization of system and digital tool for practitioners are really important. In the agenda of the Commission, in the work program of 2021 and 2022 in the program, enforcement, access to justice, and effective justice systems are issues on the top of the agenda of the European Commission. The European Commission stressed many times recently the importance of enhancing access to justice to reduce costs. As we have spoken today, cost is a problem, and digitalization could reduce the cost also for this type of procedure. The first step actually was taken, in direction of the digitalization of justice, was taken by the Council in October 2020 in its conclusion on access to justice. The Council enlightened that the digitalization path will decrease cost on the side of the judicial cooperation in international field, but also on the side of the national system themselves. And what the councils try to do is to call on the Commission to commit the Commission to ensure funding for actions related to the digitalization of justice through the regular financing, such as the main program, which is the Digital Europe program. But then the Council also encouraged member states to participate to EU calls for proposal, to participate in developing actions related to the digitalization of justice, taking the opportunities we have at the moment from the cohesion funds, the recovery and resilience facilities, and the justice program. But also at the end, the Council called on all stakeholders to cooperate in a common, constructive and sustainable effort to promote the digitalization of justice systems. And from the Italian side, from the Ministry of Justice side, I'm really pleased to inform you that in 2019, when I was the director of the office I spoke before, the ministry participated to a call. It was actually a restricted call just to members of the AJN, which is the European Judicial Network. And the ministry constituted a partnership with 4 institutional partners. That we had 2 universities, the Department of Law at the University of Ferrara, the Catholic University of Milan, the Italian School for the Judiciary, and the Italian Notariate. So this partnership got the funds and created a website which is called Adricus, the one you can see on the screen. Adricus is the website of the AJN ITA project. AJN stays for AJN ITA Italy, the Italian sections. So we managed to create this website, which main aims is to strengthen and make the European judicial network, the Italian section, more efficient, because it is still mainly unknown to judicial authorities and to practitioners. And the net, the European judicial net, is really an important tool to as I said before, to enhance the confidence on the rules and on the international mechanisms, such as the legislative instruments we have in the judicial cooperation fields. And in this web portal, you can find lots of materials, such as information on the regulation, national and international case law, links to other websites of interest, and also contribution from scholars or academics, or also judges and lawyers, to in relation to many issues that arise from the study and application of the European instruments. There are also many information on initiatives, events to deepen the knowledge on these instruments. And for example, in relation to this seminar, we had a notice that the Train to Enforce seminar would have been taking place today. So we put many links to the program and to the modalities to access and to subscribe, to participate to today's seminar. Coming back to the European landscape, after the Council note, we had a communication from the Commission at the end of 2020. With this communication, the Commission proposed a set of toolbox of opportunities for enhancing cross-border and national instruments. It is, I would say, it's a new approach, because for the first time, the Commission had a comprehensive view of legal, financial, and technical instruments to face the digitalization challenge we are going to face. And there are 2 levels of intervention, the national and the European level of intervention from the side of the Commission. There's a strong will to support member states to move ahead their national justice system toward the digital area. And also at the European level, the Commission aims at further improving cross-border judicial cooperation between competent authorities. And also the COVID-19 pandemic crisis highlighted the need to go in this direction and to accelerate national reforms, because also we face considerable impact on the functioning of the judicial cooperation. Many procedures have been badly affected, as you probably know, due to the COVID-19 pandemic crisis. It's interesting to see that in the last work program 2022 of the Commission, there is still a strong will to go ahead in the path to the digital decade, because the Commission wants to deliver the complete EU digital transformation by 2030, which is considered in a kind of way the deadline for the completion of the digital transformation of the European Union. Coming back to the end of 2020, after the communication we mentioned before, the Commission issued a proposal for a regulation. This is a very important regulation because it will set a new system for communication in cross-border civil and criminal proceeding, but of course, for what interests us today is the civil side. It is the e-codex system. It's a system which has been discussed and developed between a consortium in a project.
There is a problem of connection.
Can you hear me?
Roberta. Now, yes, we lost your last phrase.
Okay, Sarah, did you hear about the regulation on e-codex system?
Yes, the beginning.
Okay, I tried to be brief and repeat briefly. The Commission published this regulation at the end of 2020, proposal. The proposal has been discussed within the Council the first semester of 2021, and now it's in the trialogue phase. So it is discussed between the Presidency of the European Council, the European Parliament and the Commission, and we believe it should be concluded for the spring of 2022. It's an important regulation that will change a lot the judicial cooperation in civil and commercial matters, because it has a completely different system of communication between judicial authorities and for access to justice for citizens. What is e-codex in a nutshell? The meaning is e-justice communication via online data exchange. The regulation provides for a legal framework for this new system, e-codex system. So it has rules of the composition, on the function, on the management and responsibilities of all entities which operate inside the e-codex systems. The systems allows for interoperability within the IT national systems, which will connect the judicial authority and facilitate all the procedure, the European procedure between them. And of course, it will facilitate access to justice for citizens. What is interesting is that the management of this system will be given to EULISA, which is an agency of the European Commission, and that there is a proper article which states clearly that the independence of judiciary in dealing with the procedure will not be at stake, but it will be guaranteed totally and completely. The regulation does not contain rules on the mandatory use, so it's left to the singular revision of the instrument related to the single procedure to decide if the use of this system will be mandatory or not. Here you have a simple scheme where you can easily understand the way the e-codex system will work in practice. So briefly, every member state we have a kind of package of software composed by back-end applications, the one you see on the side of the screen, member state A, the three computers, member state A and member state B. These back-end applications will be connected to a connector, let's say, The connector will be connected to the gateway. The gateway will secure the connection to another gateway of a member state B. And from that gateway, the information will go to the connector and then to the backend application. This is the scheme. What does the connectors do? They, in a way, adapt, let's say, the national IT system in the way that the electronic signature or any technological means or feature will be in a kind of uncode to be understood by the other member states. So the connector has this task to adapt, let's say, adapt the technical, national technical solution to be connected to another member states. And the gate, which will be maintained and under the responsibility of the European Commission, the gate will assure a secure connection to another member state. Then the communication will arrive to member state B, and then the connector B still will operate in the same way of connector A, and will render in a way accessible the information to the back-end application of member states B. I try to be simple, but I mean it's simple the way it works. Of course, in the technological development will be very precise and not that simple. But at least I would like you to understand the general mechanism of this system. I have here a video. I'm not sure if it will work. Can you see? No, it doesn't work.
Yes,
But can you? No, sorry. No, it's the video. I try to from here.
No, we can't see the video.
No, it's not at the disposal of this type of. I think it's the platform Teams doesn't sustain the internet video. So I try to be brief. I hope I've been understandable, and my presentation is over. So I thank you for your attention. Thank you.
Thank you very much. Roberta, you have compliments in the chat. From attorneys in Trieste. Remember, your activity here. So,
I miss Trieste a lot, I confess.
We miss you. Thank you very much. You probably are sharing the participants to this training seminar because the private international law probably is going to death with this mechanism you have explained or not. I don't know. We'll invent something now, me and Marie. Thank you very much. I'm wondering if there are questions here in the chat. No. I see smiling attorney, Avvocato Marchesi. Thank you very much. Thank you to all the participants. Please fill up the questionnaire with Professor Pascale, and see you tomorrow morning at 10. And thank you very much. And we stay in touch for the Train to Enforce project. Thank you. Good idea. Greetings from Roberta Bardelle to the attorneys in Trieste. Ah sì, dalle la parola. Please, Roberta, if you want to speak again.
So I just really want to send my greetings to the lawyers. I saw today that they are here connected, but I mean, working at the Ministry of Justice is really a tough task. But I mean, I had really an important and rare chance to go to Brussels and to experience the European institutions, where the experience I had in Trieste has been really, really important. And I think the experience I had in the Court of Trieste was particularly of a high level because of also of the lawyers and academics which I had the chance to work with, and this experience I think made a difference and was really important for me to perform the tasks that I had to face when I work within the Ministry of Justice. So all my greetings and thank you for all I could learn in Trieste.
Thank you very much. Many greetings also from the presidents of the Bar Association of the Friuli Venezia Giulia, Avvocato Cuccagna, Avvocato Zanetti, Avvocato De Benedittis, Avvocato Rumiel, the president of the bar, because they are busy in Rome with the meeting of the Consiglio Nazionale Forense, but a lot of greetings to all the participants, and thank you very much again. Thank you.